You're a juror in a medical malpractice case. Why can't you go onto Google and Google the topic to learn more information during the course of trial? Why can't you Google the attorney's name and find out more information about the lawyers who you're in front of? You want to learn the answer to that question? Come join me as I share with you this great information. Hi, I'm Jerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. When you sit as a juror on a medical malpractice case in New York, the judge is going to give you very specific instructions at the very beginning of the case. The judge is going to tell you, under no circumstance are you permitted to learn any information outside of this courtroom about the attorneys, about the case, about the subject matter. Now, why not? The reason they don't want jurors doing their own independent investigation is because any information that you are going to use to make a decision and render a decision on this particular case has to come from what is contained within the courtroom. This way, everybody has an opportunity to hear it, to see it, to know what testimony is being given. Plus, there's a record of that because a court stenographer will take down all the information that's recorded based upon the questions and answers that are given. So now, if something is done wrong during the course of the jury trial, now one side or another has the ability to appeal that. Now let's say you go ahead and go online after a long day of trial and start to Google and find out information about the topic. Let's say it's a failure to diagnose sepsis resulting in death. And now you try and learn more about that information. You come back into court, and now ultimately you go into jury deliberations, and now you're having a discussion with your fellow jurors about whether or not the injured victim has proven their case. Are they more likely right than wrong? And now a discussion comes in about how you diagnose this particular condition. And you say, wait a second, I saw on the internet that you can prove this condition when the patient has the following things, and they didn't do that. So here they are, they're wrong. You're taking information that you learned outside of the trial, bringing it in, and now you become the go-to expert. Now the other jurors are going to be relying on you to determine whether or not one party or the other has proven their case. And now you become the person that they look to. And you may have the ability to sway that verdict. Why? Because you're bringing in outside information. The whole point of why the judge gives you that instruction is they don't want you bringing in outside information that might influence you or the other jurors in this particular case. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on into the litigation process in a medical malpractice case here in the state of New York. You know, I recognize that chances are you have questions or concerns about your own particular legal matter, and if your matter happened in New York and you have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I do this every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Jerry Oginski here in New York. Thanks for watching.